want to thank everyone for coming out today for our presentation, A Graceful Exit on Business Continuity and Exit Planning. My name is Roxann Smithers with Smithers and Umewabo. We are a full-service law firm for entrepreneurs and business owners, providing litigation, dispute resolution services, corporate law support, as well as employment law and employee benefits. And we're very excited to have partnered with Robroy Wiley of Smart Plan Investing to give you guys a little bit of information today about what you need to be thinking about to prepare to exit your business. And we've looked at three main topics that are the primary ways that you're going to exit your business. And that is the sellout, preparing your business for purchase, the cash out, preparing your business to fund your retirement, and the peace out, preparing your business for an involuntary exit. We both have a real passion for working with business owners, working with entrepreneurs to help them progress their businesses and also help them to make sure that their business provides the lifestyle and the life that they want to have. You have to take into consideration that exit planning also improves the value of your business while you're in your business. It's not something to think about right when you're ready to exit, because you can't necessarily always predict when that's going to happen. It helps you to turn what is often a job into an actual business that can stand on its own. And that is the difference between creating income for yourself and creating wealth for yourself. So we want to thank everybody for coming out today. Robroy and I are going to toggle back and forth as we go through these topics. Feel free at any point to ask us questions if you have them. We're going to hit pretty much four main topic areas under our scenarios. So we're going to give you a little bit of advice about management strategies. Robroy is going to give you some advice in terms of the financial strategies you need to take into consideration. I'm, of course, going to give you the legal strategies. And then throughout the presentation and at the end of each section, we'll give you some examples that we've seen with clients that we've worked with or situations that we've seen in the public sphere that kind of highlight the issues that we're looking at. We've got a little bit of information about ourselves. We're very excited. Robroy is incredibly accomplished, financial planner and financial advisor. Well, this is a quote we've got from Captain Obvious. 100% of business owners will die at some point in their lives. Okay? And then according to a 2006 Gallup poll, only 44% of American adults have a will. So it's a guaranteed event that only 44% of people are prepared for. Robert, do you want to go through these? Mm-hmm. Okay.
Yes. So, as Roxann mentioned, well, the inevitable, and we're going to talk about peace out, putting it quite eloquently that way, when the owner has a involuntary exit. So I'm going to share with you a story, and it's actual real story that happened to an advisor who I know 3 years back. And consequently, what came out of it was actually a great instrument that I use with business owners on helping them with, or if they involuntarily exit out of their business. He was working with a couple, I call them Sam and Martha, and was meeting with them. He was a financial advisor, meeting with them, and Martha made a comment that their estate was fine, but that she was really worried about what to do with the business if something were to happen to Sam. And Sam was 55 years old and pretty much seemed to be in healthy condition. Financial advisor said, well, I'll put some things together, and over the next 6 months, we'll try to kind of figure out maybe some strategies or something. I'll see what happens. And 12 days later, Martha calls up the financial advisor and says, Sam died. Sam was running on the treadmill. He had a heart attack and hit his head on the board. And consequently, the only person who I knew to call if something were to happen to him was you. So the financial advisor had to quickly get into the business. He knew that Sam was in the middle of acquiring another entity. So thinking that the right thing to do was to tell the bank that the owner, that Sam had passed away, the bank consequently said the line of credit is closed because they consider death as default. And that left him in the position of how are we going to pay the employee salaries? How are we going to meet the interim financial obligations of the business? And we also have to get a grief counselor for the daughter because she's having issues. The son who was in the business was trying to kind of muddle through with what was going on. And they had to quickly place the wife in as the president of the business. Fortunately, she was listed as the secretary of the business, so they could speed things up. They were able to secure a line of credit to help pay the employees and even whatever incoming accounts payables that were needed to be paid. But really what came out of it was a business continuity instruction communication manual. And this is something that I work with on the business owner because it goes into great detail as far as if something were to happen to the owner, who gets alerted and who takes the leadership in the business. But what more or less also, what to say to clients and vendors. They're very quick to call up with their condolences, but a client may be wondering, am I going to get my product? Who's going to be taking care of it? Vendor might be wondering, when am I going to get paid? And also, consequently, what happens if your vendors or your competition gets wind of it and they start calling your key managers and your key employees and actually recruiting them? It did actually happen in this instance. But going through this manual as far as if you're in the process of acquiring another business, whose name is the line of credit in? Who are all the key players, the attorneys, the CPA? Where are all the legal documents for the business? Where are they at? Also dealing with lines of credit and who is going to take on the responsibility? Is it going to be 3 or 4 people in the company that are going to take on the owner's various jobs and duties that they did? And then who is going to manage all those key client accounts during the process? And because you want to try and retain the business value, especially through your employees, because they're going to be the ones that are going to be speaking to the clients and to the vendors. As we know in this social media, digital world, excuse me, news travels rather rapidly. And then also dealing with securing information, dealing with even cybersecurity. So the Atlanta was hacked, so dealing with who is actually even going to be responsible for that and the owner in the organization to make sure that client and vendor information is secured also. And designation, of course, I mentioned this already, but client ownership, your key clients, who takes on dealing or managing that relationship in the business, because you really do want to retain that value, especially as an owner. If you're thinking that the business is going to help either pay for your spouse's retirement or help in the future pay for even maybe education for the children or whatever the revenue or the profit of the business, whatever the plans, you want to try to minimize that risk. Also, you don't want to have the personal estate to have to cover the business expenses. In this case, the life insurance policy on Sam was $3 million. And they had to take $1 million of that life insurance policy to cover some of the expenses and the acquisition of the other business that was going on. So if the financial advisor had known that beforehand, would have recommended that the business have some type of key man insurance in place which is something that I do with my clients, because that helps give a cash flow for helping if you have to bring in somebody like a temp or meeting responsibilities. It gives you the cash to help maneuver during the time and to get more or acclimated on how the business is going to move forward. The family will not be emotionally available. So if you think that your spouse is going to be gung-ho on dealing with with death and managing or figuring out how to run a business, you have to think twice about that. And also, if you have any pending sales, acquisitions, and loans that are contingent upon the owner being alive, as Roxann said about the sign of contracts with the owner's name versus the business. And you don't want to have you want to try to minimize the depletion of business value and the brand name. Especially if in the event of an involuntary exit of the owner, if the family is making the decision on selling the business. Because one of the things in the communication manual is who has actually expressed interest in maybe buying the business or a portion of the business. So you kind of know who to approach if that did happen. And because you want to avoid a fire sale. You basically want to avoid either having to declare bankruptcy, close the doors, and if an owner, I put it this way, if an owner at least cares about their employees somewhat, to have some type of communication on how the business moves forward, because they will be the ones that will be wondering, am I going to get paid? How is the business going to move forward if we can't meet those obligations? So now I return it back to Roxann for the legal side.
A couple things, additional points of recommendations on the management strategies from a legal perspective. In terms of the business continuity instructions, you'd want to have two things to think about for your business. Just like for yourself, when you do your estate planning, in addition to the will, you may have an advance directive, which gives your loved ones guidance on what you want done if you are in a state where you cannot speak for yourself, in terms of how you want to be handled, how much intervention do you want to have, do you want to be on life support, these different things. You can have a version of an advance directive for your business, making sure that your key people, your family, know what you want done with the business, what you'd like to have done with the business in the event that you pass away while you're in the middle of your business. Having a place where it's laid down what your plans were, things that you're discussing and negotiating, so that someone else can kind of step in that place. And even having contingency plans just if you're incapacitated in some form or fashion where you cannot make business decisions, or you just physically cannot go out and execute the business of your business, going to the bank, talking to customers, those sort of things, having those things in place. The best way that you can think about it, or the test that you can do, think now, if you went on vacation, would your business continue to operate without you being involved? If the answer is no, think about what are the things that your business cannot do with you away on vacation. And that gives you an idea of the areas that you need to make plans for or make contingencies for. So we think about it from a happy standpoint. But those are the gaps that you need to think about. And that can be as little as having it written down. How do you do invoicing? What's your process for taking in orders? What's your process for providing your service? Where are things? Where are the files? Where are the supplies? Just having those things available list. What are the passwords? Where are the passwords? We all have 50 million passwords. Where are they? So that if someone has to get in and do the simplest of things, that they're able to do those things in your absence. That also means that you get to go on vacation. All right, so legal strategies. First and foremost, have a will. It does not have to be the fanciest will that you've ever seen in your entire life, but you need to have a will. designating what you want to happen to your assets. And your business is one of your assets. So you have to think about how you want that handled. Who do you want to sort of be the beneficiary, either in terms of maintaining and obtaining control of your business or obtaining the revenue or the assets or the value from that business if the business is no longer going to exist once you have your piece out. As Robroy mentioned, one of the things that you want to make sure you have is you can have a life insurance policy for you that the business is the beneficiary for. This does a couple things. One, if you are the key rainmaker and revenue generator for your business still, this gives a cushion of some revenue, replaces some of that revenue in the interim period, particularly if you intend for the business to continue without you. Even if you have partners and they plan to continue the business, this gives them cushion to have time to replace you, either to pay someone until they get ramped up, or to simply just replace that revenue. You can also, it can be life insurance or key person policies that are in place for that. Make sure that I said all of your contracts and your accounts are in the name of the business. Because once you pass away, your estate can end up in this limbo, and it's even more of a limbo if you don't have a will. It's to go through probate court. It takes time, and there's expense involved, and the more you are personally linked to the business, the more that process will tie up and slow down your business, and could ultimately bring your business to a halt where you intended for the business to survive without you. Your corporate resolutions, your bylaws, your operating agreements, the other documents that sort of authorize what happens for your business, they need to clarify what individuals are able to do and what they're designated to do on behalf of you or on behalf of your estate while your estate is going through the probate process. So you can designate who are the other officers of your business, particularly if you have business partners. If you're the main manager, who takes over as manager if you're not available, so that they can continue to run the business. It's depending on what they need to get done, they'll need to have proper documentation to show that they're authorized to do those things for the business. A bank may want to see corporate resolutions to certain effects if you are trying to sell things or get loans or continue a line of credit for the business. That business continuity plan or dissolution plan, particularly that's sort of having the will for your business. How do you want the assets of the business to be distributed? Do you have a key company or a key individual in mind that you would like to refer your existing customers or clients to? And what's the process for that? Will they have access to your files? Will they have access to that information? How that gets communicated? You can put that in an operating agreement. You can put that in other documents for your business.
And on a side note too, dealing with businesses that are operating like on a service, like a CPA, legal, even financial, or type of service entity, there is a way to be able to formulate if something happens with a competitor or type of agreement with somebody who is a business that is like yours in another market or in your market, for they to come to terms as far as if something happens, they will help step in, continue working with clients and pay the estate or the owner a certain percentage of the revenue that's coming in. Instance, works with a CPA who had a heart attack in the middle of tax season, had this practice continuation agreement in place. And so it was a bigger CPA firm that came in, continued servicing the client's accounts and paid a certain portion of that revenue to the CPA. It also can work on if there is death or the involuntary exit of the owner, that they can come in and help with that continuity in the business.
Yeah. And depending on the type of your business you're in, for example, there are states where if you're a solo attorney and you're responsible for individuals' legal rights, that you have to file with the state who is your backup person to handle your clients and handle your files if you pass away or you're incapacitated, because there are key deadlines that our clients are going to have to deal with. But those are things that can come into play in any type of business, particularly if you intend for the business to survive after your exit and to thrive after your exit. You don't want to lose people in that transitional period, because that's where a lot of times changes are made or competitors swoop in or things like that. So you can even create a little bit of funding for your estate if you do a continuity plan with a competitor, and that they've got to then return revenues to you, some portion of those revenues, in exchange for getting your business referrals or getting your clients. That can help fund your estate. Oftentimes in either operating agreements or the bylaws, they'll designate what happens if one of the members, even if you're solo or if you have partners, what happens if a member does have an involuntary exit and passes away. Whether or not that triggers an automatic dissolution of the business and a wind down of the business, or whether or not your beneficiaries, your heirs, do they inherit your ownership interest as well as your management say in the business, or do they simply inherit a income interest in the business and they won't have a say in how the business is going to run? Or does your passing away automatically force a sale of your shares and your interest, and the business is required to then buy out your estate? And that's another reason why the insurance is key, or having those funds are available, because now the business has to figure out how to pay for your interest and pay your estate. And you can do that if they're cash strapped. You can have that insurance policy that can fund that purchase. And you can have either in those agreements or have a separate agreement that is that buy-sell agreement that dictates what happens if you pass away. So knowing that, because you may think, you've got business partners, you may think, well, I pass, well, automatically my family, my spouse, or my child is going to take my place in the business. Not if the operating agreement doesn't say that. It may force a sell and push your family out, or it may leave them in. And if you have partners, you may decide, I don't think I want my partner's spouse to be my new partner if my partner passes away. So thinking about how you want those provisions laid out in advance are often very important. As part of this, you also want to think about, in addition to the will, the other documents that, as I said, should be in place short of death. You want to have your advance directive that lays out what happens to you, but also can lay out what happens to the business, and limited financial power of attorney, which gives someone the legal authority to conduct business for you. It can be as broad or as narrow as you want it to be. And they're accepted by most businesses. You can have one uniform power of attorney. Then in most cases, businesses will accept. They'll want it to be on file with them. And that means so you can talk to the IRS, you can talk to the bank, you can open accounts, close accounts, sell assets. And you can make it as broad as you want in terms of the powers that the person has, or as narrow. And you can even do it for a time period. It's particularly good if you're just sick or you're injured and you want it to go into effect, and it only go into effect for 60 days, 90 days. And then if you're incapacitated further, you'd have to take other legal steps like a conservatorship if you're in some sort of long-term state where you cannot function. But those are good temporary things that you can put in place in advance if something happens and you're not available. Any questions on the legal strategies for that piece out?
I I do.
Okay.
How often should you revise your business continuity plan in addition to the buy-sell agreements and those other documents that should complement the overall plan?
The buy-sell agreement, pretty much once you do it, if your decision in terms of what you want to do with your buy-sell agreement doesn't change, then once you have your buy-sell agreement or your buy-sell provisions in your operating agreement, those can last. If you do strategic planning every couple years, it's advisable to just sort of take a look at your documents and make sure they actually reflect what you are doing. I mean, as our business, we had our operating agreement, and as we were functioning, you start saying, well, we're not really doing this that way, and we didn't think about this piece. And so we, look at it and decide if you want to make any changes. But as long as it is reflecting what you're actually doing and reflecting how you want to handle things, then once you've done a pretty well thought out operating agreement or buy-sell agreement, then they pretty much are set it and forget it. If you want to change designations of individuals, something happens to someone moves, or someone else passed away that you have designated, then you may do an amendment to update that. But you don't necessarily have to do a full overhaul under any specific timeline. Any other questions? Yes, ma'am.
So you all have mentioned bylaws a couple of times, and on the operating agreement and or the bylaws, you talked about this being included. So this could go on. So just briefly, what else are some of the things that should be in the bylaws, and then what is sort of the basic difference between the bylaws and the operating agreement?
Sure.
Kind of
Basically, bylaws and operating agreements serve the same purpose. Bylaws are for corporations, so an S corp and a C corp, and an operating agreement is for a limited liability corporation. The other agreement that you're not going to see often would be a partnership agreement if you do a partnership, either a traditional P or a limited liability partnership. Then you'd have a partnership agreement. And it's basically the contract or the blueprint for how the business operates. So it identifies who are the members, who are the owners, what their shares are, how they put money into the business, how you take money out of the business, how often those things happen. It designates who's responsible for making decisions for the business, who can sign contracts, who, depending if you're manager or officers in the terms of the bylaws. It can designate what happens if someone passes or someone dies. And it can also dictate how people leave the business, whether that's selling their shares voluntarily, whether they're being voted out of the business, and how that is handled and how it's financed. If you think about your certificate of formation, which when you register with the state, you get your nice we're formed, that's your birth certificate, if you think about it as a person. Your operating agreement, your bylaws, your partnership agreement, that's sort of the DNA. And your DNA dictates how your body actually functions. And that's sort of a good way to think about the difference between the two. But they're critical to have, because once you are trying to figure out how to handle situations, if you don't have those agreements, then you fall back on state law, which will give you default positions that you may or may not be happy with. So that's like you buy a new electronic device. The default position is what your ringer is, what your font is, what the background is. Having your operating agreement is you personalizing to the ringtone that you like, the alarms that you like, the picture that you want for your background. So if you don't do that, then you're stuck with the default positions that are in law.
Yeah, I have a story about that.
Okay. And then final, just an example, tails from the front on that. Client updated the operating agreement and the resolutions to reflect the ownership and interest and management roles of the children who were working in the business. Excuse me for the typo. Prepared will to leave his remaining interest to his spouse as interest income only. And then the operating agreement provided for the income interest by a member who inherits. So that sort of goes back to that example that I gave, that your operating agreement, your bylaws can dictate that your interest either passes fully and that person literally steps into your shoes in the business, or something short of that, or can force a sale. And it's just something to think about either for your spouse or if you're in a partnership with someone else, whether you want their spouse as your business partner if something happens to them. Robroy?
I actually have recently, can't say too much about it, but dealing with operating agreement, because I will ask my clients if they have an operating agreement in place. And you want to make sure, one, to really work with Roxann, because you wanted the operating agreement to be as ironclad as possible, especially if you're entering into a partnership and they are friends of yours. Seen instances where those partners have actually, behind the scenes, started another company, kind of copied what was going on. So the operating agreement really needs to be like ironclad, and that somebody like Roxann coming in and filling out those details that you don't really kind of foresee or think about. They had an operating agreement, but it was not as detailed as it needed to be. And consequently, they had to wind down one of their businesses.
Yeah. And so as we wrap up, we also just want to remind everybody that the things that you do to prepare your business for an exit are also a lot of the things that you just want to do to have a healthy business and to have a prosperous business while you're in it. It also gives you some ideas about the difference between creating a job for yourself and creating a business that can stand on its own. And as I said at the beginning, a job creates income. A business that can stand on its own, you're creating wealth for yourself. So we want to thank you for coming and thank you for participating. And you've got your handouts. If you guys have additional questions for us, you've got our contact information. Please feel free to reach out to us. And here's our contact information again. Thank you.
Thank you.